Yeah. The International Criminal Tribunal for the former Yugoslavia is now in session. L'Audience du Tribunal Pénal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Good morning, everybody. I apologize for starting 5 minutes or 6 minutes late, but we had a technical fault which we were trying to fix. Unfortunately, we haven't fixed it, but we decided to start nonetheless. Today will be a little bit more formal. When it comes to representation, I will be asking you to identify exactly who is and who isn't here. For the record, all the accused are present. I just want to make sure that you are receiving interpretation in your own language or in a language that you understand. Yes, I see all the accused nodding. So let's proceed to representation, prosecution. Mr. McCloskey.
Good morning, Mr. President, Your Honors, everyone. My name's Peter McCloskey for the prosecution, and with me today is Nelson Thayer, Kweku Vanderpuye, Janet Stewart, Jelena Plamenats, Chris Mitchell, Caitlin Chittenden, Rupert Eldricken, Lada Sholyan, and Julian Nichols, who for the life of me I couldn't figure out who he was, but thank you.
Thank you, Mr. McCloskey. Presentation for accused Popovic.
Good morning, Your Honor.
Good morning.
For Mr. Popovic, Zoran Jovanovic, lead counsel, Ms. Mirta Pušković, co-counsel, Mr. George Kalanj, legal assistant, and Ms. Leon Andrczyk, legal assistant. Thank you.
Thank you. A representation for accused Beara.
Good morning, Your Honors. My name is John Stojic here on behalf of Mr. Beara.
Thank you. Representation for accused Nikolic.
Good morning, Your Honors. My name is Jelena Nikolic. With me, Mr. Stefan Burgon, Ms. Caroline Touchard, our legal assistant. Thank you.
Thank you. Representation for accused Borovchanin.
Good morning, Mr. President, Your Honors. My name is Christopher Gosnell. I'm here on behalf of Mr. Borovchanin, and with me are Tatiana Chmerich and William Byrne.
Thank you. Representation for accused Militic.
Natasha Fovo-Ivanovic, representing General Militic with Mr. Petrovic Nenad.
Merci, Madame. Representation for accused Guerrero.
Good morning, Your Honors. Good morning, everyone. On behalf of General Guerrero Defense, Dragan Krgovic, lead counsel, David Joss, Michelle Butler, and Dion Zogovic.
Thank you. And finally, representation for accused Pandurovic.
Myself, Peter Haynes, Mr. Simon Davis, and our case manager, Helena Kaka.
I thank you. So let's proceed. The trial chamber is sitting today to deliver its judgment in the case the prosecutor versus Vujadin Popovic, Ljubisa Beara, Drago Nikolic, Ljubomir Borovchanin, Radivoje Miletic, Milan Guerrero, and Vinko Pandurovic. I shall now read a summary of the trial chamber's findings in that judgment. However, the authoritative account of those findings is contained in the judgment, which will be made available after this hearing. At the outset, the Chamber wishes to express its gratitude to all counsel, past and present, the registry staff, the interpreters, court reporters and technicians, the security officers, and staff at the United Nations detention facility, the trial chamber's own staff, and all others who have contributed to the smooth and efficient conduct of this trial. Trial proceedings in this case commenced on the 21st of August 2006 and concluded on 15th September 2009. In that time, the trial chamber has heard or otherwise admitted evidence from 315 witnesses. A total of 34,915 transcript pages records what was heard in court. There were 5,383 exhibits before the trial chamber, amounting to 87,392 pages. Over the course of a few days in July 1995, following the fall of Srebrenica, thousands of Bosnian Muslim males were detained in deplorable conditions, transported to various remote locations, and summarily executed. In parallel to these mass executions, Bosnian Muslim women, children, and the elderly were transferred out of this part of eastern Bosnia. In the context of the war in the former Yugoslavia and in the context of human history, these events are arrestive in their scale and brutality. The trial chamber wishes to emphasize that while the horrific crimes committed in and around Srebrenica and Zepa in July 1995 form the basis for this case, the trial is ultimately about 7 men: Vujadin Popovic, Ljubisa Beara, Drago Nikolic, Ljubomir Borovčanin, Radivoje Miletic, Milan Gvero, and Vinko Pandurovic. The trial is about these 7 men and their alleged individual criminal responsibility. The trial chamber will first list the charges brought against the accused. It will then provide a summary of the factual allegations that underpin the crimes charged. Next, it will examine the specific crimes and the criminal responsibility for each accused. Finally, it will render its verdict. I'll start with the accused. The prosecution alleges that 2 joint criminal enterprises existed in eastern Bosnia and Herzegovina in July 1995. One was a joint criminal enterprise to murder the able-bodied Bosnian Muslim men from Srebrenica, which I will be referring to as the JCE to murder, and the other was a joint criminal enterprise to forcibly remove the Bosnian Muslim population from Srebrenica and Zepa. I will be referring to this joint criminal enterprise as the JCE to forcibly remove. By virtue of their acts and omissions, 5 of the accused, that is, Vujadin Popovic, Ljubisa Beara, Drago Nikolic, Ljubomir Borovčanin, and Vinko Pandurovic, are alleged to be responsible for genocide under count 1, conspiracy to commit genocide under count 2, extermination being a crime against humanity in count 3, murder, a crime against humanity and a violation of the laws or customs of war in counts 4 and 5 respectively, persecution, a crime against humanity in count 6, inhumane acts consisting in forcible transfer, a crime against humanity in count 7, and finally deportation, a crime against humanity under count 8. All 5 accused are alleged to have been members of the JCE to murder and the JCE to forcibly remove, and are charged under every form of individual responsibility set out in Article 7.1 of our statute. In addition, Ljubomir Borovčanin and Vinko Pandurovic are alleged to be responsible pursuant to superior responsibility under Article 7.3 of the statute. By virtue of their acts and omissions, 2 of the accused, Radivoje Miletic and Milan Gvero, are alleged to be responsible for murder, a crime against humanity and a violation of the laws or customs of war under counts 4 and 5 respectively, persecution, a crime against humanity under count 6, inhumane acts consisting in forcible transfer, a crime against humanity under count 7, and deportation, a crime against humanity under count 8. Radivoje Miletic and Milan Gvero are alleged to have been members of the JCE to forcibly remove and are charged under every form of individual responsibility set out in Article 7.1 of the statute. I now turn to the trial chamber's findings in relation to the commission of the alleged crimes by the Bosnian Serb Forces. I note at the outset that the judgment sets out the background of the events alleged from 1992. For the purpose of this summary, however, the trial chamber will limit itself to events that took place between March and September 1995. In March 1995, Supreme Command Directive 7 was issued by President Karadzic. The directive set out the criminal plan for an attack against protected United Nations safe areas aimed at forcing the civilian populations of Srebrenica and Zepa to leave the enclaves. It tasked the Drina Corps to create, quote, an unbearable situation of total insecurity with no hope of further survival or life for the inhabitants of Srebrenica and Zepa, unquote. It also detailed that, quote, the planned and unobtrusively restrictive issuing of permits, unquote, should be undertaken so as to limit the supply of material resources to the population and logistics support of the United Nations Protection Force, which I will be referring to as UNPROFOR. In the implementation of this plan, from at least June of 1995, the aid supply decreased significantly as a result of the Bosnian Serb army restrictions, creating an increasingly dire humanitarian situation in Srebrenica and Zepa enclaves. Henceforth, I will be referring to this Bosnian Serb army as the VRS. On 6th July, the VRS started its military attack on this Srebrenica enclave, an operation known as Krivaja 95. Several days of intense shelling followed, with Srebrenica town and the compounds and observation points of the Dutch battalion of UNPROFOR, which I shall be referring to as Dutchbat, being amongst the targets. On 11 July, the enclave, including the town of Srebrenica, fell. As a result of the attack from 10th July, thousands of Bosnian Muslims started fleeing from Srebrenica town to the Dutchbat compound in Potocari, desperate for protection. While mostly women, children, and the elderly fled to Potocari, Bosnian Muslim men from Srebrenica gathered in villages in the valleys of the Srebrenica enclave. In the late evening, these men formed a column which set off in the direction of Tuzla, which was in the territory held by the army of Bosnia and Herzegovina. I will be referring to this army as ABIH. In order to reach Tuzla, the column had to break through VRS-held positions. The column consisted of about 10 to 15,000 individuals, mostly men, and with both a civilian and a military component. Meanwhile, 3 meetings took place between representatives from the VRS and Dutchbat at the Hotel Fontana in Bratunac over 11th and 12th July. So-called unofficial representatives of the Bosnian Muslim population also attended the 2nd and 3rd meetings. The parties discussed the logistics of moving over 10,000 Bosnian Muslims from Potocari and its surroundings, and Mladic told the Bosnian Muslim representatives, quote, "You can either survive or disappear. For your survival, I demand that all your armed men surrender their weapons to the VRS," unquote. By the morning of 12th July, a decision had been taken to separate the Bosnian Muslim men in Potocari and execute them. On that same day, the VRS dispatched approximately 50 buses to Potocari, where members of the Bosnian Serb Forces, that is, VRS Forces, Ministry of the Interior in Republika Srpska, MUP Forces, began separating men aged 15 to 65 from the women, children, and the elderly who were boarding the buses. Already on the verge of a humanitarian disaster, a night of utter misery ensued at the Dutch Bat compound. People were frightened, some died. Members of the Bosnian Serb Forces took away men who did not return, and women were heard screaming, "Let me go," and "Please don't." The transfer and separations continued throughout the next day. Members of the Bosnian Serb Forces confiscated and eventually burnt the separated men's belongings, including passports and identity papers, and detained the men at various houses in Potocari. They were given no food, hardly any water, and sanitary facilities were scarce. Members of the Bosnian Serb Forces transported the separated men towards Bratunac. The Bosnian Serb Forces thwarted efforts by Dutch Bat soldiers to escort the convoys and record the men's names. On 13 July, there were several random killings of Bosnian Muslims by members of the Bosnian Serb Forces, including at the Luk school and in Potocari. By the evening of 13 July, between 20 and 30,000 Bosnian Muslims had been bussed out to ABIH-held territory, and no Bosnian Muslims remained in Potocari or Srebrenica. The trial chamber has found that this constituted forcible transfer, including by majority Judge Kwon dissenting with respect to the civilian component of the column. Meanwhile, on 12th and 13th July, the VRS deployed several units along various routes in order to engage militarily and block the column of Bosnian Muslims that was moving from Srebrenica to Tuzla. By this point, the murder plan originally directed at the men in Potocari was extended to Bosnian Muslim men who were captured or surrendered from the column. By 13th July, Bosnian Serb forces had detained approximately 6,000 Bosnian Muslim prisoners in the Bratunac area. The prisoners were forced to surrender their property, which included identity cards, wallets, watches, and food. They were kept in cramped conditions and received some water, although hardly any food. Members of the Bosnian Serb forces did not ask or record names. Some of those of the detained prisoners became victims of opportunistic killings. On 13th July, VRS Commander Ratko Mladic issued a telling order prohibiting filming and photographing of prisoners and preventing access by, quote, unauthorized, unquote, and, quote, uninvited, unquote, entities. At the same time, a series of meetings were held over 13th and 14th July between members of the civilian authorities and VRS members, at which the logistics of the killing and burial operations were the central objects. On 13th July, the murder operation began in earnest. Members of the Bosnian Serb Forces shot and killed Bosnian Muslim prisoners on the banks of the Jadar River, at an area along a dirt road in Cerska Valley, the Bratunac Brigade headquarters, and Sandici Meadow, and in and around the Vuk Karadzic school in Bratunac town. On the same day, Bosnian Muslim prisoners who were captured or surrendered from the column close to Sandici Meadow were marched or transported to the nearby Kravica warehouse. There, what appears to be a busload of prisoners were initially killed after a prisoner had grabbed a weapon, killing one member of the Bosnian Serb Forces and wounding others. What followed this initial killing episode can only be described as a massacre of the prisoners held in the warehouse. Members of the Bosnian Serb Forces besieged the prisoners with gunfire and grenades. The assault upon the prisoners lasted through the night. By the end, at least 1,000 Bosnian Muslim men had been killed. Excavators arrived on 14th and 15th of July to remove the bodies. Further mass executions followed in Zvornik shortly after. Over 13th to 17th July, the detained Bosnian Muslim men were taken by the Bosnian Serb Forces in buses and trucks from Bratunac to various places of detention in Zvornik. The men endured a brief but horrific period of detention in various public buildings, mainly schools. The facilities were woefully inadequate. The men were taunted along ethnic lines and largely denied food and water. An atmosphere of terror was maintained through beatings and sporadic executions. Their spirits broken, the Bosnian Muslim men were taken for execution. Some were blindfolded and their hands were tied, and at one detention site they were given a final glass of water. Then they were transported to nearby locations and shot. This scene played out at a field in Orahovac, a dam at Petkovci, a gravel pit in Kozluk, and a farm in Pilica. In addition, hundreds were killed inside the Pilica Cultural Center, an execution for which there are no known survivors. Loaders and excavators were either already at the sites at the time of the executions or arrived soon after to bury the dead in mass graves. In the wake of these mass executions, the Bosnian Serb Forces ordered a so-called mopping up operation throughout the enclave, and executions on a smaller scale continued in the Zvornik area between the 16th and the 27th of July 1995. The members of the column who had not surrendered or been captured had continued to move towards ABIH territory. By 15th July, the column had reached the Zvornik Brigade's area of responsibility, and heavy fighting took place. However, on 16th and 17th July, a corridor several hundred meters wide was opened in the defense lines of the Bosnian Serb Forces, allowing a significant part of the column to pass to ABIH-held territory. These Bosnian Muslim men escaped the murder operation. During September and October 1995, in an effort to conceal the killings, the VRS, with the assistance of the civilian authorities, carried out a large-scale operation in the areas of Zvornik and the Bratunac brigades, during which bodies of execution victims were moved from their primary graves to secondary locations. An extensive amount of forensic and demographic evidence was presented in this trial. This evidence is analyzed in detail in the judgment. Based on this evidence, the trial chamber has found that at least 5,336 identified individuals were killed in the executions following the fall of Srebrenica. However, noting that the evidence before it is not all-encompassing, the trial chamber is satisfied that the number of identified individuals will rise. The trial chamber therefore considers that the number of individuals killed in the executions following the fall of Srebrenica could well be as high as 7,826. The scale and nature of the murder operation, with the staggering number of killings, the systematic and organized manner in which it was carried out, the targeting and relentless pursuit of the victims, and the plain intention apparent from the evidence to eliminate every Bosnian Muslim man who was captured or surrendered, proves beyond reasonable doubt that this was genocide. As these events played out north of Srebrenica, the VRS also maintained a military focus on the Zepa enclave. The VRS initiated discussions regarding the removal of the population of Zepa before arriving militarily at the enclave. 3 rounds of negotiations took place. At each juncture, military force was the means used by the VRS to compel concessions from the Bosnian Muslim population of Zepa. As the attacks continued, they intensified. Further, news about the fate of the Bosnian Muslims from Srebrenica began to circulate, adding to the panic of the population, and loudspeakers broadcasted a message that there was no chance for the Bosnian Muslim population as the area was controlled by Mladic. Ultimately, in the face of these impossible conditions, the population had no choice but to leave the enclave. As one witness described, the choice was, quote, to leave Zepa under very cruel and humiliating circumstances, or to remain and then either be killed or be subjected to suffering, unquote. Most of the transportation of the civilians took place on 26th July, and by the following day, the 27th, around 4,000 or 5,000 Bosnian Muslim women, children, and elderly and wounded were transported by bus out of Zepa. As of 31st July, when negotiations as to their fate appeared to have stopped, the Bosnian Muslim able-bodied men of Zepa, civilians and military, fled in various directions, including across the Drina River to Serbia. These men also faced the same situation as the civilians, and they had no choice but to escape the enclave. While a so-called agreement was signed to give a veneer of legitimacy to the movement of the Bosnian Muslim population of Zepa, the trial chamber has found that this constituted forcible transfer, including by majority Judge Kwon dissenting, of the able-bodied men who fled to Serbia. I now turn to the legal findings. The trial chamber will now summarize its key the interpreters on the English channel. I'm now receiving the Serbo-Croat translation. If that could stop, it would help me immensely. The trial chamber will now summarize its key legal findings. The trial chamber has found that there was a joint criminal enterprise to murder and a joint criminal enterprise to forcibly remove with several participants. The trial chamber has found that opportunistic killings were committed in the course of the JCE to murder and by majority, Judge Kwan dissenting, in the course of the JCE to forcibly remove. Further, it has found that some members of the JCE to murder had genocidal intent and thus genocide was committed. It has also found that members of both JCEs had the requisite special intent for the crime of persecution. It has also been established beyond reasonable doubt that there was a widespread and systematic attack against a civilian population. This attack commenced with the issuance of Directive 7 and had various components, including the strangulation of the enclaves through the restriction of humanitarian supplies, the gradual weakening and disabling of UNPROFOR, and a planned military assault on the enclaves, and culminated in the removal of thousands of people from Srebrenica and Zepa. Therefore, applying the legal elements of the crimes charged in the indictment to the facts found to be proven, the trial chamber has found that the following crimes were committed by members of the Bosnian Serb Forces in various locations alleged in the indictment: genocide, conspiracy to commit genocide, extermination, a crime against humanity, murder, a crime against humanity and a violation of the laws or customs of war, murder, cruel and inhumane treatment, terrorizing civilians, and forcible transfer as acts of persecution, a crime against humanity. And finally, forcible transfer as an inhumane act, a crime against humanity. The trial chamber finds that the elements of the crime of deportation have not been established. I now turn to individual criminal responsibility of each of the accused, starting with Vujadin Popovic. Vujadin Popovic was the chief of security of the Drina Corps in 1995, and he held the rank of lieutenant colonel. On 12th July, Popovic forecasted the planned separations, transfers, and killings in the enclave when speaking to Momir Nikolic prior to the third Hotel Fontana meeting. He told Momir Nikolic that, quote, all the Balias have to be killed, unquote, and asked him to assist in the operation. Popovic was present with the Bosnian Serb Forces in Potocari on 12th July, and the trial chamber has found that Popovic was aware of the large number of men among the thousands of Bosnian Muslims gathered at Potocari on this day. The trial chamber has found that Popovic had knowledge of the operation to capture men along the Konjevic-Polje Road on 13th of July. That evening, Popovic phoned Drago Nikolic to inform him that a large number of prisoners would be brought from Bratunac to Zvornik in order to be killed. He asked Drago Nikolic to assist in this operation. On 14 July, Beara, Popovic, and Nikolic met at the Standard Barracks, which was the Zvornik Brigade's headquarters in Karakai, to organize and coordinate the killing operation. Following this meeting, Popovic carried out the initial steps required to put the plan in action when he accompanied a convoy of buses carrying Bosnian Muslim prisoners from Bratunac to Gerbavci School in Orahovac. The trial chamber has found that later that day, Popovic was present at the field in Orahovac as the executions took place. On 15th July, Popovic was present at the Rochevich school, organizing personnel and equipment to facilitate the detentions at the school, as well as the executions which occurred later that day at a gravel pit near Kozluk. Also on this day, Popovic gave the Zvornik Brigade duty officers instructions to not record any information concerning the Bosnian Muslim prisoners, nor should he speak about them over the radio. The following days, that is 16th of July, Popovic was present at yet another site where prisoners were detained prior to execution. I'm referring to the Kula school in Pilica. On this day, Popovic requested the delivery of fuel from the Zvornik Brigade in relation to the execution and burial of prisoners in Pilica. Drazen Erdemovic, so described Lieutenant Colonel at Pilica several times on 16th July, including at the Branievo military farm execution site. The, quote, Lieutenant Colonel, unquote, was organizing personnel to participate in the executions. For the reasons outlined in the judgment, the trial chamber is satisfied that this so-called Lieutenant Colonel was Popovic. That evening, Popovic asked that a message be conveyed to, quote, the general, unquote, that he had, quote, finished the job, unquote. And the next day, 17th July, Popovic again told an unknown interlocutor, whom he referred to as the boss, that, quote, all gets an A, unquote. For the reasons outlined in the judgment, the trial chamber is satisfied that in both of these conversations, Popovic was referring to the killing operation. Later in July 1995, 10 wounded Bosnian Muslim men came to be held at the headquarters of the Zvornik Brigade. Sometime after 23rd of July, these men were placed in Popovic's custody. For the reasons outlined in the judgment, the trial chamber is satisfied that Popovic either killed or facilitated the killing of these 10 wounded Bosnian Muslim men. The trial chamber is satisfied beyond reasonable doubt that during these days, Popovic was fully engaged in the organization of the killing operation being carried out in the Zvornik area. For the reasons set out in the judgment, the trial chamber has found that Popovic was a member of the JCE to murder the Bosnian Muslim males of Srebrenica, and that he participated in the joint criminal enterprise with persecutory intent. The trial chamber has found that Popovic was not a member of the JCE to forcibly remove the Bosnian Muslim civilian population from the enclaves. Popovic was not a marginal participant in the JCE to murder. He knew of the plan from the time of its inception and was privy to each development. From the discussions at Bratunac before the operation began, to the capture of the Bosnian Muslim men from the column, to the large-scale killings at Zvornik, Popovic was entrenched in several aspects of the operation, and he participated with resolve. He was ubiquitous in the Zvornik area, present at all but one of the major killing sites. Popovic knew that the intent was not just to kill those who had fallen in the hands of the Bosnian Serb Forces, but to kill as many as possible with the aim of destroying the group. Popovic's ensuing robust participation in all aspects of the plan demonstrates that he not only knew of this intent to destroy, but also shared it. I'll now deal with accused Beara. In July 1995, Ljubisa Beara was Chief of Security in the VRS Main Staff, and he held the rank of Colonel. He was the superior to Popovic and Nikolic in the professional sense. On 13 July, Beara was present in Bratunac and was seen at a number of places where Bosnian Muslim men were detained. Intercepted conversations from this day record Beara discussing Bosnian Muslim prisoners. Although the record of one conversation indicates that Beara was looking to simply detain the prisoners, the trial chamber is nevertheless satisfied, for the reasons set out in the judgment, that the conversation was deliberately misleading as to the fate that awaited these Bosnian Muslim men. Several witnesses testified that Beara was present in Bratunac and took part in informal meetings held at the SDS offices between 13th and 14th of July 1995. The evidence of these witnesses is analyzed in detail in the judgment. The trial chamber is satisfied that Beara participated in these meetings, the subject matter of which was the logistics of the planned killing operation, including the location for the killings and burial, as well as transportation and equipment. Beara's coordinating role in the murder operation continued throughout 14th of July. He sourced construction machinery, enlisted the help of the civilian authorities to assist with the burials, and inspected possible detention and/or execution sites. Beara was also present at the Gerbavci School and the Petkovci School on 14th of July, where prisoners were detained prior to being executed. On 15th of July, Beara continued to enlist personnel to carry out the killing operation, and intercepted conversations record his thinly veiled attempts to solicit resources. Beara told General Kirstic that he had, quote, 3,500 parcels, unquote, that needed distributing, and pressured him to assign troops for that purpose. In another conversation, he discussed the killing operation in terms of conducting a, quote, triage, unquote. On 16th of July, Beara was at Kula School in Pilica, where prisoners were being held prior to execution. As the most senior officer in the security branch, the trial chamber is of the opinion that Beara had the clearest overall picture of the massive scale and scope of the killing operation. From his presence in Bratunac on the 9th of the 13th, to his personal visits to the various detention and execution sites and the significant logistical challenges he faced throughout, Beara had a very personal view of the staggering number of victims destined for execution. Steeped in this knowledge, the trial chamber is of the opinion that Beara effectively became a driving force behind the murder enterprise. For the reasons detailed in the judgment, the trial chamber has found that Beara was a member of the JCE to murder the Bosnian Muslim males from Srebrenica, and that he participated in that JCE with persecutory intent. The trial chamber has found that Beara was not a member of the JCE to forcibly remove the Bosnian Muslim civilian population from the enclaves. Beara's vigorous efforts to organize locations and sites, recruit personnel, secure equipment, and oversee executions all evidence his grim determination to kill as many as possible, as quickly as possible. His encounters with Miroslav Deronjic on the 9th of the 13th of July provide a chilling illustration of a mind set on destruction. He announced an intent to, quote, kill all, unquote, the detained men, and without pause to consider or comment upon the horrific nature of his so-called orders, he launched into a series of heated exchanges about the best location for this reprehensible undertaking. For these reasons, which are outlined in the judgment, the trial chamber is satisfied that at this time, Beara was a man intent on destroying a group by killing all the members of it within his reach. Beyond all reasonable doubt, he harbored genocidal intent. I'll deal with Drago Nikolic. In July 1995, Drago Nikolic was the Chief of Security in the Zvornik Brigade and held the rank of Second Lieutenant in the VRS. On the evening of 13 July, Nikolic was informed by Popovic that the able-bodied Bosnian Muslim men from Srebrenica were to be brought from Bratunac to Zvornik to be killed. Popovic asked Nikolic to assist in the murder operation, and Nikolic subsequently sought release from the forward command post for this purpose. The evidence shows that from that moment, Nikolic became an active member of the JCE to murder the Bosnian Muslim males from Srebrenica. During the evening of 13 July 1995, Nikolic made preparations for detaining the prisoners at Orahovac and was at Orahovac giving directions to the Zvornik Brigade military police who had been released to him for that purpose. For much of the day, on 14th of July 1995, Nikolic was present at the Gerbavci school in a coordinating role and gave directions at the Orahovac execution site. On 14 July, Nikolic ordered the 1st Battalion of the Zvornik Brigade to secure the prisoners at the Kula school in the awareness that they would be executed. Nikolic was also present with Popovic near Petkovci school while prisoners were held there, most of whom were killed the next day. On 15th July, Nikolic, working closely with Beara and Popovic, was involved in organizing the detention and execution of prisoners at Rocevic school. The evidence shows that Nikolic demonstrated a resolve to carry out his assigned tasks in this murderous operation. His contribution to the JCE to murder can properly be described as persistent and determined. However, Nikolic's knowledge of the murder operation is of a different nature from that of Beara and Popovic. Nikolic was first informed of the murder plan on the evening of 13 July. On the evidence before the trial chamber, the information he was given was sparse, and it came at a time when the murder operation was already well underway. Further, at that point, other than his general understanding that these were prisoners taken as a result of the attack on and the fall of the Srebrenica enclave, there was no evidence that he had information as to the circumstances by which these men had ended up in VRS custody. Thus, the trial chamber has found that on 13th July, when he joined the common plan, Nikolic was aware of the plan to murder on a large scale, but not of some of the key features of the operation which would evidence genocidal intent. However, the trial chamber has further found that from his interactions with Popovic and Beara, and from his own observations at the school and execution site at Orahovac on 14 July, Nikolic soon became aware that this killing operation was being carried out with genocidal intent. Nonetheless, for the reasons set out in detail in the judgment, including the nature of Nikolic's acts and participation, as well as his personal circumstances and position, the trial chamber is not satisfied beyond reasonable doubt that he shared this genocidal intent. In these circumstances, the trial chamber has found that Nikolic participated in the JCE to murder with persecutory intent, that he had knowledge of the genocidal intent of others, and that he made a substantial contribution to genocide. The trial chamber has found that there is no evidence that Nikolic participated in the JCE to forcibly remove or that he contributed to it. I now turn to Ljubomir Borovchany. During the time relevant to the indictment, Ljubomir Borovchanin was deputy commander of the Special Police Brigade, which I will refer to as SBP, of the MOP forces. On 10th July 1995, Borovchanin was appointed commander of a joint force of MUP units, which was subordinated to the Drina Corps and sent to Bratunac to participate in the Srebrenica operation. Borovchanin was present in Bratunac and Potocari between 11th and 13th of July 1995, when the plan to forcibly remove culminated in the actual forcible transfer of the Bosnian Muslim women, children, and the elderly. The evidence does not demonstrate that Borovchanin was aware of the plan nor of its incremental implementation prior to his arrival in Bratunac. On 12 July, however, with his presence in Potocari and what he witnessed there, the trial chamber has found by majority, Judge Juan dissenting, Judge Juan dissenting, that Borovchanin came to know that there was a forcible transfer of the civilian population of Srebrenica taking place. The evidence is insufficient, however, to demonstrate that Borovchanin shared the intent to forcibly transfer himself. The trial chamber has found that Borovchanin was not a member of the JCE to forcibly remove. However, on the 12th of July, Borovchanin left the Yahorina recruits in Potocari under his subordinate commanders Jevic and Mane, with orders for them to participate in the process whereby the Bosnian Muslim population was to be removed from the area and transported to ABIH territory. They continued to do so on 13th of July and were instrumental in executing the physical forcible transfer. While there is no evidence that Borovchanin shared the intent to forcibly transfer or had the intent to discriminate, with his knowledge of the intent of others as found by the majority, including discriminatory intent, Borovchanin's acts in ordering his men to participate constituted a substantial contribution to the crime of forcible transfer. While Borovchanin was in Potocari, Bratunac, and on the Bratunac-Konjevic-Polje road, where the plan to murder the Bosnian Muslim men was developed and put into place, the evidence is insufficient to find that he had any knowledge of this plan or that he shared the intent to contribute to the common purpose of the criminal enterprise to murder. On 13th July, Borovchanin arrived at the Kravica warehouse, where over 1,000 Bosnian Muslim men were detained. Outside, in front of the warehouse, he saw a number of dead bodies, what appeared to be a busload. Borovchanin knew that his units were amongst the Bosnian Serb forces with custody and or control of the Bosnian Muslim prisoners that day, and therefore had a duty to protect the remaining prisoners in the warehouse. The first and only step Borovchanin took after seeing the evidence of prisoner executions was to remove himself and his men from the Kravica warehouse as quickly as he could. Borovchanin had the means to protect the prisoners and knew that it was probable that the prisoners would be killed. Borovchanin's failure to protect the Bosnian Muslim prisoners then still detained substantially contributed to the full-scale execution which later took place at Kravica warehouse. The trial chamber is also satisfied that Borovchanin knew that the prisoners at Kravica warehouse would probably be killed by members of the Bosnian Serb Forces there with discriminatory intent. Further, Borovchanin was the superior of the SBP 2nd Sekovinci detachment, having arrived at the Kravica warehouse shortly after the murder of a busload of prisoners, he had knowledge, which was sufficient to put him on notice, that his subordinates had committed the crime of murder. For the reasons detailed in the judgment, he failed to take the necessary and reasonable measures required to punish his subordinates for the murders of the busload of Bosnian Muslim prisoners at Kravica warehouse. I now turn to Radivoje Miletić, who in 1995 was the chief of the administration for operations and training at the VRS Main Staff. A significant amount of time during the trial proceedings was devoted by the prosecution and the defense for Miletić to establish the nature and extent of his powers at the time relevant to the indictment. The trial chamber is convinced that from at least May to October 1995, Miletić, in addition to his regular responsibilities, took on certain duties from the Chief of Staff Manojlo Milovanovic. However, the trial chamber is not satisfied that Miletić was Deputy Chief of Staff of the VRS Main Staff or was officially, quote, standing in, unquote, for the Chief of Staff. Most importantly, though, the trial chamber has not assessed Miletić's criminal responsibility on the basis of title or even assigned or undertaken responsibilities, but rather on the basis of the factual evidence of his acts and conduct which has been adduced before it. Miletić drafted Directive 7 and whatever his level of input in terms of content or wording, he was intimately acquainted with its final text, including the incriminatory parts. As such, from the early stages, Miletić had full knowledge of the common criminal plan to force the Bosnian Muslim populations from the Srebrenica and Zepa enclaves, and he was instrumental in the plan being captured in writing for dissemination. Through his central role in the drafting process of Directive 7 and of Directive 7/1, Miletić contributed to the joint criminal enterprise to forcibly remove. Miletić further played a role in the process for the approval of humanitarian convoys. Through this, Miletić implemented the instructions of Directive 7 to incrementally and unobtrusively deprive the enclaves of humanitarian aid and UNPROFOR of supplies with the purpose of creating an untenable situation for the population and strangling UNPROFOR. By doing so, Miletić again contributed to the JC to forcibly remove. Considering the scale and scope of the military attack on and the operations to forcibly remove the Bosnian Muslims from the enclaves, coordination from the main staff level was essential. Miletić, with his in-depth knowledge of the strategies and goals of the VRS, was at the center of this coordination. Through the reports he received from subordinate units and his direct contact with the forces in the field, Miletić was fully attuned to all developments in the field and informed on the progress of the operations. Miletić forwarded the knowledge he gained to Mladić and Karadzic, while at the same time he ensured the flow of information from the main staff to subordinate units. Milovanovic, the Chief of Staff and Miletić's direct superior, captured the essence of Miletić's role at the main staff when he called him, quote, the soul of the main staff of the VRS, unquote, and the person, quote, best informed on the situation in the various theaters of the war, unquote. Miletić skillfully and efficiently used his unique position to inform and advise, and thereby enabled the decisions taken to successfully implement the plan, resulting in the forced removal of thousands of Bosnian Muslims from the enclaves. Through these acts, Miletić contributed to the JCE to forcibly remove. Considering all the individual acts and contributions cumulatively, The trial chamber concludes that Miletić made a significant contribution to the JCE to forcibly remove. Miletić furthermore shared the common intent of the JCE. In addition, he carried out his acts in furtherance of the plan to remove the Bosnian Muslims with the specific intent to discriminate on political, racial, or religious grounds. Based on Miletić's level of involvement and his in-depth knowledge and broad overview of the massive operation to forcibly remove the Bosnian Muslims from Srebrenica, it was foreseeable to him that murder would be committed in Potocari and that these murders would be committed with the specific intent to discriminate on political, racial, or religious grounds. Judge Kwon dissents on the foreseeability to Miletić of the killings in Potocari. I turn now to Milan Gvero. In 1995, Milan Gvero was the assistant commander for moral, legal, and religious affairs of the VRS Main Staff and directly subordinated to Mladić. In this position, and as one of the most senior officers in the VRS Main Staff, Gvero played an important role in VRS operations, and this was no different for the operations in Srebrenica and Zepa. Through his knowledge of key documents from 1992 and his involvement in the drafting of Directive 7, Gvero knew of the plan to forcibly remove the populations from Srebrenica and Zepa enclaves from its very inception, and of the VRS's role in this plan. Gvero had to be informed of major developments in the operations so that he would be in a position to act if issues of morale arose or dissemination of information was necessary. Accordingly, key documents were specifically addressed to him, such as Tolimir's telegram forwarding Karadzić's order to capture Srebrenica, Tolimir and Mladić's instructions concerning prisoners of war, and documents concerning the negotiations in Zepa. The need for Gvero to be fully attuned was enhanced the need for Gvero to be fully attuned was enhanced by the fact that on occasion he was the most senior officer present at the main staff, in which case other assistant commanders reported to him and he could be called upon to intervene directly in ongoing military action. During the Srebrenica and Zepa operations, Gvero carried out key functions relating to external propaganda and interaction with international organizations, with the aim to support the plan to forcibly transfer the populations from the enclaves. On 10th July 1995, after the VRS had launched its military assault on the enclave, taken over United Nations observation points, and moved to capture Srebrenica town, Gvero issued a statement to the media concerning the attack on Srebrenica enclave, stating that the VRS activities were directed at neutralizing Muslim terrorists and not against any civilians or UNPROFOR. Though not criminal as such, the purpose of this blatantly false statement was less innocent. Gvero made this statement with the intention to mislead the international authorities concerned with protecting the enclave, with a view to delaying any action that could frustrate the VRS plans. On 11th July, as part of the combined VRS efforts to stop the NATO bombing on the VRS forces approaching Srebrenica town, Gvero adopted the same approach as the day before. He falsely asserted to UNPROFOR's Chief of Staff General Nicolai that the VRS was merely responding to attacks, while knowing that the VRS had taken the town and that Bosnian Muslim men had fled to Potocari. Gvero further threatened Nicolai by stating, in essence, that failure to stop the NATO bombing could result in serious consequences for UNPROFOR and the civilians in Potocari. The trial chamber is satisfied that Gvero issued this threat with the aim to halt NATO bombings so that the VRS could complete its plan to take over the Srebrenica enclave and forcibly remove its Bosnian Muslim inhabitants. Soon thereafter, Gvero warned the VRS personnel on the treatment of UNPROFOR forces to avoid any action that could provoke a response and interfere with the efforts to end the NATO bombing. With regard to the Zepa operation, though Gvero was clearly knowledgeable as to the illegal purpose of and developments in the Zepa campaign, the trial chamber has no evidence to find that Gvero contributed to it. Based on these factors combined, and for the reasons detailed in the judgment, the trial chamber has found that Gvero made a significant contribution to the JC to forcibly remove and shared the common intent. Furthermore, Gvero acted with the specific intent to discriminate on political, racial, or religious grounds. However, considering the nature of Gvero's acts and his level of involvement in the operation to forcibly remove, the trial chamber is not satisfied that it was foreseeable to him that murder would be committed in Potocari. I now turn to the last of the accused, Vinko Pandurovic, who was commander of the Zvornik Brigade and held the rank of lieutenant colonel in 1995. As commander of Tactical Group 1, Pandurovic was aware of the criminal objective described in Directive 7 and of the plan to forcibly remove the Bosnian Muslim populations from Srebrenica and Zepa enclaves. Pandurovic and Tactical Group 1 participated in the attack on Srebrenica on 6th July and entered Srebrenica town on 11th July. While the evidence is insufficient to conclude that Pandurovic intended to carry out the common purpose of the JC to forcibly remove, the trial chamber has found that Pandurovic's participation in the military attack and takeover of Srebrenica enclave substantially contributed to the forcible transfer of the civilian population from Srebrenica. The trial chamber is also satisfied that by participating in the attack on Srebrenica enclave, Pandurovic knew that he was assisting in the commission of persecution. With respect to Zepa, the trial chamber has found that Pandurovic did not make a contribution, significant or substantial, to that forcible transfer, nor did he share the intent to forcibly remove. On 15th July, Pandurovic was ordered to return to the Zvornik area of responsibility to block or crush the column and prevent the column from joining up with the forces of the ABIH 2nd Corps. Upon his arrival to the standard barracks on 15 July, the trial chamber is satisfied that Pandurovic was told by his chief of staff that pursuant to Mladic's order, Beara and Popovic had brought a large number of prisoners from Bratunac to Zvornik, where they were executing them, and that there were enormous problems with the guarding, execution, and burial of prisoners. In the following days, Pandurovic received additional information, including about the detentions and executions and burials in Pilica, Petkovci, Rocevic, Orahovac, and Branivo military farm. By 18th July, Pandurovic had information as to the overall scale of the murder operation. However, there is no evidence to establish that Pandurovic shared the intent to commit the crimes that formed part of the JCE to murder. There is also no evidence that Pandurovic himself participated or that he ordered, authorized, or otherwise approved the participation of his subordinates in the murder operation. In the period between 13th and 16th July, members of the Zvornik Brigade participated in guarding the detained Bosnian Muslim prisoners and in transporting the prisoners to execution sites in the area of Zvornik. The trial chamber is satisfied that members of the Zvornik Brigade provided practical assistance that had a substantial effect on the commission of the executions of the prisoners. Upon his return to Standard Barracks at noon on 15th July, Pandurovic had reason to know that his subordinates had committed, were committing, or were about to commit crimes in relation to the detention, execution, and burial of the Bosnian Muslim prisoners in the area of Zvornik. As detailed in the judgment, the evidence before the trial chamber shows that Pandurovic did not genuinely attempt to take any measures within his material powers in order to prevent any further or continued participation of his subordinates in the murder operation. With respect to his duty to punish, however, in the unique and extraordinary circumstances Pandurovic faced, the trial chamber considers that Pandurovic's actions were such that he is not responsible for a failure to punish. On 16th July, Pandurovic opened the corridor to allow passage of the column through Zvornik Brigade territory to the territory held by the ABIH 2nd Corps. This was contrary to the orders he had received from his superiors. Thousands of men passed through this corridor. After the corridor was closed on 18th July, and during the subsequent few days, elements of the Zvornik Brigade participated in searching the terrain for ABIH soldiers. Around 20th of July, 10 wounded Bosnian Muslim prisoners were transferred from Zvornik Hospital to the clinic of the Zvornik Brigade. On the 23rd of July, Pandurovic requested instructions from the Drina Corps regarding the wounded Bosnian Muslim prisoners in his custody. The trial chamber is satisfied that Pandurovic was informed that Popovic would come to take the wounded prisoners. The trial chamber is further satisfied that the wounded men were placed in Popovic's custody on the 23rd of July and that Popovic was responsible for their death. Although the trial chamber has found that Pandurovic did not possess the intent to murder the 10 wounded Bosnian Muslim prisoners, the trial chamber has found, by majority Judge Korn dissenting, that Pandurovic knew it was probable that the wounded prisoners would be murdered once they were transferred into Popovic's custody. By failing to intervene, Popovic failed to discharge his legal duty to protect the wounded prisoners and therefore substantially contributed to the murder of these 10 men. I now come to the verdict. Will the accused, Vujadin Popovic, please rise? For all the reasons I have summarized. The trial chamber finds you, Vujadin Popovic, to be guilty pursuant to Article 7.1 of the statute of the following counts. Count 1, genocide. Count 3, extermination as a crime against humanity. Count 5, murder as a violation of the laws or customs of war. Count 6, persecution as a crime against humanity. In relation to the following counts against you, on the basis of the principles relating to cumulative convictions, which we explain in the judgment, the trial chamber does not enter a conviction for count 2, conspiracy to commit genocide, and count 4, murder as a crime against humanity. You are found not guilty and therefore acquitted of the following counts. Count 7, inhumane acts consisting in forcible transfer, a crime against humanity. And count 8, deportation, a crime against humanity. In the face of the grave nature of the crimes perpetrated and your significant responsibility for them, the trial chamber considers that the only appropriate sentence for you is life imprisonment, to which you are hereby being sentenced. You may sit down. Will the accused Ljubisa Beara please rise? For all the reasons I have summarized, the trial chamber finds you, Ljubisa Beara, guilty pursuant to Article 7.1 of the statute of the following counts. Count 1, genocide. Count 3, extermination as a crime against humanity. Count 5, murder as a violation of the laws and customs of war. Count 6, persecution as a crime against humanity. In relation to the following counts against you, on the basis of the principles relating to cumulative convictions, the trial chamber does not enter a conviction under count 2, conspiracy to commit genocide, and count 4, murder as a crime against humanity. You are found not guilty and therefore acquitted of the following counts. Count 7, inhumane acts consisting in forcible transfer, a crime against humanity. And count 8, deportation, a crime against humanity. In the face of the grave nature of the crimes perpetrated and your central responsibility for them, the trial chamber considers that the only appropriate sentence for you is life imprisonment, to which you are hereby being sentenced. You may sit down. Will the accused Drina Corps please rise? For all the reasons I have summarized, the trial chamber finds you, Drina Corps, guilty pursuant to Article 7.1 of the statute through aiding and abetting of the following count. Count 1, genocide. You are found guilty pursuant to Article 7.1 of the statute of the following counts. Count 3, extermination as a crime against humanity. Count 5, murder as a violation of the laws or customs of war. And count 6, persecution as a crime against humanity. In relation to the following count against you, on the basis of the principles relating to cumulative convictions, the trial chamber does not enter a conviction for count 4, which is murder as a crime against humanity. You are found not guilty and therefore acquitted of the following counts. Count 2, conspiracy to commit genocide. Count 7, inhumane acts consisting in forcible transfer, a crime against humanity. And count 8, deportation, being a crime against humanity. The trial chamber hereby sentences you to a single sentence of 35 years imprisonment with credit for the time you have already served in detention. You may sit down. Ljubomir Borovchanin, would you please rise? For all the reasons I have summarized, the trial chamber finds you guilty pursuant to Article 7.1 of the statute through aiding and abetting of the following counts. Count 3, extermination as a crime against humanity. Count 5, murder as a violation of the laws or customs of war. Count 6, persecution as a crime against humanity. And count 7, by majority, Judge Kwon dissenting, inhumane acts consisting in forcible transfer being a crime against humanity. In relation to the following count against you on the basis of the principles of cumulative convictions, the trial chamber does not enter a conviction pursuant to Article 7.1 of the statute for count 4, that is murder as a crime against humanity. The trial chamber also finds you guilty as a superior pursuant to Article 7.3 of the statute of the following counts. Count 4, murder as a crime against humanity, and count 5, murder as a violation of the laws or customs of war. You are found not guilty and therefore acquitted of the following counts. Count 1, genocide. Count 2, conspiracy to commit genocide. And count 8, deportation, a crime against humanity. The crimes for which you stand convicted are of a very grave nature. However, as detailed in the judgment, the trial chamber considers that the particular circumstances which you faced in relation to the forcible transfer and the nature of your criminal responsibility, which with respect to murder and extermination is predicated on aiding and abetting by omission and superior responsibility, diminishes the gravity of your criminal conduct. Having considered all these factors in combination, the trial chamber hereby sentences you to a single sentence of 17 years imprisonment with credit for the time you have already served in detention. You may sit down. Radivoje Militic, would you please rise? For all the reasons I have summarized, the trial chamber finds you, Radivoje Militic, guilty pursuant to Article 7.1 of the statute of the following counts. Count 4, by majority, Judge Kwon dissenting, murder as a crime against humanity. Count 6, persecution as a crime against humanity. Count 7, inhumane acts consisting in forcible transfer, a crime against humanity. You are found not guilty and therefore acquitted of the following counts. Count 5, murder as a violation of the laws and customs of war. Count 8, deportation, a crime against humanity. The trial chamber hereby sentences you to a single sentence of 19 years imprisonment with credit for the time you have already served in detention. You may sit down. Will the accused Milan Gvero please rise? For all the reasons I have summarized, the trial chamber finds you, Milan Gvero, guilty pursuant to Article 7.1 of the statute of the following counts. Count 6, persecution as a crime against humanity. Count 7, inhumane acts being forcible transfer, a crime against humanity. You are not found guilty and therefore acquitted of the following counts. Count 4, murder as a crime against humanity. Count 5, murder as a violation of the laws or customs of war. Count 8, deportation, a crime against humanity. The trial chamber, having considered the extent and nature of your involvement and mitigating factors set out at length in the judgment, hereby sentences you to a single sentence of 5 years imprisonment with credit for the time you have already served in detention. You may sit down. Will the accused Vinko Pandurovic please rise? For all the reasons I have summarized, The trial chamber finds you guilty pursuant to Article 7.1 of the statute through aiding and abetting of the following counts. Count 4, by majority, Judge Kwon dissenting, murder as a crime against humanity. Count 5, by majority, Judge Kwon dissenting, murder as a violation of the laws or customs of war. Count 6, persecution, a crime against humanity. And count 7, inhumane acts, being forcible transfer, a crime against humanity. The trial chamber also finds you guilty as a superior, pursuant to Article 7.3 of the statute of the following counts. Count 4, murder as a crime against humanity, and count 5, murder as a violation of the laws or customs of war. You are found not guilty and therefore acquitted of the following counts. Count 1, genocide. Count 2, conspiracy to commit genocide. Count 3, extermination as a crime against humanity. And count 8, deportation, a crime against humanity. The crimes for which you stand convicted are of a grave nature. However, as detailed in the judgment, in arriving at an appropriate sentence, the trial chamber has considered the limited nature of your involvement in the forcible transfer, the circumstances you faced upon your return to Zvornik area, and the nature of your criminal responsibility, which for murder is premised on aiding and abetting by omission and superior responsibility. Further, the trial chamber considers that there are several mitigating factors to be taken into account in your sentence, most significantly your act of opening the corridor for the passage of the column. Having considered all of the relevant circumstances, the trial chamber hereby sentences you to a single sentence of 13 years imprisonment with credit for the time you have already served in detention. You may sit down. Judge Prost appends a separate opinion to the judgment, and Judge Kwon appends dissenting and separate opinions to the judgment. The hearing is now adjourned.
All rise for your evaluate.